So what we're going to do now is go straight into the question and answer. As I said before, this is going to be exclusively question and answer. They have no more prepared speeches to talk about. So if you have questions, if you could go ahead and stand up here in a line, I hope there's a line, to have your questions answered. Over the last couple days, we've also been taking anonymous questions in the UC. So I'm going to start with one. If there's ever a time where there's nobody that wants to ask a question, we'll just go down the list. So the first one we're going to start with, and also if you don't direct it at a specific panelist, any panelist can jump in and answer. Okay. Hold on, I lost it. Okay. So the first question is, can you explain probable cause in layman's terms so that I know what it means? For example, is the smelling of marijuana coming from a car probable cause, and can you give more concrete examples? So, have it.
Can I answer that one?
Sure.
It's funny, Brett, you asked that question. I think there's actually a case on that. It's a good question. I'm going to say one thing. I may misspeak tonight. I may give you guys bad information. Don't believe anything I say, okay? That's a disclaimer. You believe what you want to believe. But I'll tell you as best I can, okay? My understanding is, my reading of the law is, there's a case back in the 70s. It's called Schoendollar, and it was actually, the defense attorney on it is now in the Montana Supreme Court, if I'm not mistaken. And that was the smell. It was a PC probable cause. Was there a probable cause to search a car based on smell, marijuana smell? But the cop said, I smell marijuana. I think he said burnt marijuana. And he got a warrant. And on appeal, do you know what that means, appeal? What does that mean? It means, I'm going to just give you a little primer, okay? Well, if you go to court and your lawyer argues something and the judge says denied, your defense attorney argues something, the judge is always going to say denied, okay? That's their line. Now, it's the truth. It's all right. It's okay. You got to just appeal that to the Supreme Court, and the judges might do something a little different. They're not as politically motivated, okay? So, you appeal it. The Supreme Court says, in this case, smell is not enough. Smell? How could smelling burnt marijuana be probable cause to believe that marijuana will be found in the car? Use your common sense for a second. How much marijuana was burned? Okay? How much marijuana wasn't burned? How much was left? Was it all burnt or was half burnt? How long ago was it burned? Do you understand that if I burn something and you smell the burnt product, it doesn't mean that there's anything left. It's gone. Okay? Or maybe it's half gone. Does it mean that there's probably unburnt material in the car? You think about it. Of course not. That's what the Supreme Court said. No, doesn't get you there. Now, I think you got smell cases in the dorm. If you're in the dorm room and there's somebody smells marijuana, officer or resident's life, and they try and get a warrant, I think they got problems. They might get the warrant, okay? And then that doesn't mean that you're going to rant and rave. You know, if they come and they say we got a warrant, then let them in. You can't fight them. But you hire a lawyer, and your lawyer challenges that warrant. And if the district court says, then you appeal it to the Supreme Court, and you cite that case, and you'll win. That's my short answer.
So, I'm not sure I agree with everything Craig just said.
That's great.
Of course. So, to back up, probable cause is generally defined as whether a reasonable person, taking into account all that they know and understand at that time, have a belief that a crime is being committed and that this person has committed it. That's probable cause for an arrest. Probable cause to search is whether a reasonable person would believe a crime has been committed and evidence of that crime would be where you want to look. All right, so that's probable cause standard. And the officer needs probable cause to make an arrest. So if they're going to arrest you, they need to have probable cause prior to that sort of intrusion into your privacy. But smell of marijuana is, well, first of all, I think in the federal system, smell of marijuana is plenty. That's probable cause, both for arrest or for search. And I think that it certainly is going to be enough for them to stop and ask you questions. And if you're in a car and they smell burning marijuana or burnt marijuana, the odor of marijuana, you're toast. Because they're going to have then probable cause to suspect that you're driving under the influence if you're the person driving, right? I also think that probable cause doesn't mean an absolute certainty. It's probable cause. And the beauty of probable cause from the state side, of course, is you could be wrong. That's just the way it works. You don't have to be exactly right. Would a reasonable person believe that a crime is being committed and this person committed it? Well, if you smell someone smoking marijuana, or you smell smoke, then I think a reasonable person suspects that this person has marijuana on them or is committing some other offense. They could be wrong, but that's not the standard. Whether you're right or wrong, the standard is you have probable cause. And I think that will give them a basis to certainly intrude on your personal freedoms.